and service marks, geographical indications, industrial designs, patents, layout designs of integrated circuits, and undisclosed information. Ang undisclosed information, yung trade secret, no? So, whether you are in the private sector or in the government, isang law lang naman yan, ano? So, nagkakaiba siguro sa ibang rules, sa mga licensing protocols, no? So, I won't discuss these IPRs at length, but I found a more comprehensive table prepared by the Association for Management and Valuation of Intangibles, or AMAVI, which more or less describes these IPRs. Next slide, please. Okay, so makita nyo, intellectual property, no? You've got patent, utility model, trademark, industrial design, copyright, and know-how. Okay, know-how. And then, yung mga elements niya, no? What distinguishes one from the other? So, nakikita yung differentiation. Let's say in the feature, no? Pag patent utility model, technical siya. So, pag trademark, ito yung mga non-technical. Industrial design, although ang industrial design is under the patent law, no? It's essentially yung itsura niya eh. Hindi yung kanyang technical function, no? Kasi dapat non-functional siya, no? And then copyright, so non-technical. Ngayon yung know-how, pwede yang technical or non-technical. So, what does it protect? Okay, that one familiar kayo, no? Product, process, or application. Okay, sign words, appearance. Now, protectability requirements. Okay, universal pa rin yan, ano? For patents and utility model. Novelty, except sa utility model sa Pilipinas, hindi requirement ang inventive step, ano? Kasi kung lang siya, registration process, so all you have to do is you comply with the formalities. But of course, sometimes yung mga nagda-draft dito ng patent, ano, minsan you can experience yung mga examiners na iba, no, when they talk of, let's say, gusto nila ng mas clear. Ayun, minsan pumapasok sila doon sa para silang gumagawa ng substantive examination. Okay, sa trademark naman, kailangan siya ay distinctive. And then sa atin, kailangan nakikita pa rin, ano, graphical ang representation. But meron tayong, what do you call this? Proposed revision ng IP code wherein we are, the IPOFIL is recommending na yung sound. Hindi siya ano? Hindi siya tangible. Sound, tsaka yung smell, pwedeng ipasok. Right now, yung mga non-traditional natin, nando sa 3-dimensional marks. Yan. Hindi siya traditional kasi hindi siya usual. Okay. Copyright, okay. Individual, and kailangan original. Territory, ito naman kasi pang international kasi itong graph na to, no? So, tayo national lang. Within the Philippines lang, ano? Yung regional, meron niya yung EPO. Meron yan yung sa Africa, yung ARIPO. Ano pa ba? Yung sa medyo bandang Russia, yung Eurasian group. Okay, the duration also would depend country by country, no? So, sa atin naman 20 years lang from filing. Ang utility model sa iba 10 years, pero sa atin 7 years lang. Okay? Cost naman, expensive. Ang expensive sa patent yung kanyang annuity. At saka minsan, let's say, for example, kung medyo complicated yung invention mo, tapos napakaraming claims, yan, pwedeng maging mahal yan, ano? Okay. But I think yung DOST supports yung mga ganyang klaseng program, ano? So, nililibre nila yung drafting ng patent. Okay, next slide, please. Okay, the Department of Trade and Industry, as well as the United Nations Development Program, are one in saying that MSMEs or micro, small and medium-sized enterprises are the backbone of the Philippine economy. So ito ay 2022 data, no? So here you can see 99.6% of all registered businesses are MSMEs. And then about 65% of total employment comes from MSME. And then, hindi lang nakalagay dito, ang MSME contributes about 40% of the GDP and 25% of our exports, no? So, talagang siya ay tunay na backbone. And then the top sectors, ayan, retail, food, and manufacturing. Ano ba ang usually problema ng MSME sa mga IP? Wala silang kwan eh. Sometimes wala silang trademark, they don't care much about it, or design or patent protection. So itong mga grupong ito underutilize ang IP, no? So this is an area where introduction of IP to help MSMEs to be more productive, profitable, and more stable, and to be able to expand their business. So, next slide, please. So, if you tunnel down yung kung ano yung composition ng MSME, makita mo na ang micro enterprises, 90.4% ang kwan siya ng total business, total MSME, no? So, napakalaki. So, ano ba yung mga micro? 5 minutes na lang ba? Ikakat na lang natin, ano? Okay. 5 minutes? Okay. So, anyhow, so, sino yung mga micro? Di yan yung mga small retail establishments mo. Yung mga sari-sari stores yan, And then, okay. So, next slide, please. Ayan, ang top industries by number of MSMEs, wholesale, retail trade, repair of motor vehicles. So, wholesale and retail trade, naintindihan natin yan kasi maraming nag-i-import mula China, no? So, ang mga Chinese goods naman, they have been improving. So, mura pa, di ba? Itong repair of motor vehicles, I think this is more like napakadami nating jeepneys and tricycles, no? And also, baka we have this habit na kinikip natin yung ating mga sasakyan kahit kahit luman-luma na, no? So, pinipilit natin silang paandarin. Okay? Next slide, please. So, so there's no doubt that kailangan tulungan ng MSMEs, ano? So, sabi nga ni Attorney Medrano, di ba? Helps in building reputation, yung IP, improves market position, profitability, enhances competitiveness, etc. And then, according to study nga, e-commerce presents a great opportunity. Pero, nung 2015, 6% lang yata ang Bitcoin, may access sa e-commerce o na internet, But that was 2015. Baka ngayon marami na. Okay, next slide, please. Okay, siguro baka isang case lang masasabi ko, Sige. Okay, so just to help us understand, kung ano ang relation ng IP law sa commercialization. Okay, etong PhilSCAP case, bago-bago ito, Although nag-umpisa siya ng, I think, 2000-something, 2014 ba? Yeah. And then, 2004. And then ngayon lang na-decide, 2025. So, about 21 years na nakakaraan, So, ano nga ba ang PhilSCAP? A collective management association siya, So, they represent mga writers, singers, etc. Ganyan, And then they collect. Kailangan kasi magbayad ka ng license for public performance. But in this case, ang sinabi dito, pag yung itong si Wolfpack, na ang kanyang business, nagbebenta siya ng ringtone. Pero, para makapamili yung mga yung mga tao, kailangan mapakinggan yung ringtone, So, ang sabi nung PhilSCAP, hindi, magbayad ka ng license. Sabi ng hindi, kwan lang yan eh. Sandali lang yan at saka hindi siya public performance, So yun nga, sabi ng Supreme Court, hindi siya public performance. Hindi siya public performance, kundi communication to the public siya. So under siya ng fair use. Kasi paano nga ba makaka-decide yung mga tao, kung anong pipiliin nilang ringtone? 'Di ba? Kailangan mapakinggan nila. Okay? So, time na ba ako? 2 minutes. Okay. Okay, talagang Philscap. Alam mo yung mga Philscap agents, no? They go around restaurants, hotels, they listen to the music. And when kung pakinggan nila na, kasama to sa aming listahan, kailangan may lisensya. So kagaya etong sa COSAC case na to, so yung restaurant played music for ambience without public performance license. So kinasuhan siya ng Philscap kasi ayaw niya magbayad eh. So ang sabi ng Supreme Court, public performance nga naman yon. So I think for small businesses, kailangan mag-ingat kayo na huwag kayong basta mag-play. No? Lalo na kung halimbawa natin, may maliit kang eatery, pero meron kang amplifier dyan. Ikaw na yun, public performance na yon. Kailangan magbayad ka na lisensya. Okay, next. 1 minute. Okay, Lacos. Ito, kaso na we handle this case, no? So it's under a motion for reconsideration ng Lacos. So ano nga ba? We represented Crocodile, isang Singaporean company, no? Okay. So magkamukha ba sila? Sabi ng Supreme Court, na naniwala sa amin hindi Kasi meron siyang word. At saka magkaiba yung crocodile nila I think yung isa ay alligator, Kaya yan. So now, okay, so the court applied the dominancy test and ruled in favor of Crocodile of Singapore. Okay. So that now, naka-appeal ngayon yan. Naka-motion for recon ng Lacoste. Okay na ako? 1 minute pa rin. Okay. Next. Patent. Sa Philip Seafood Philippine Corporation versus tuna processors, no? So, di ba mahilig tayo nung, ano ba yung kinu-cure? Tuna, fish curing method. Tuna yan Very popular yan sa Zamboanga, no? So, walang patent infringement, whether literal or under the doctrine of equivalence. Bakit? Dahil sa pag-literal ng infringement, kailangan lahat ng elements ng patent mo nandoon sa infringer, no? Kung wala, walang infringement. Ngayon, doctrine of equivalence naman, ang sinasabi, pwedeng hindi lahat pareho, pero kailangan yung means, yung function, tsaka yung element, nandoon magkapareho, no? So dito, wala rin. Kasi dito, ang kaibahan nila, etong si Philips, kwan siya, ano pangalan to? Ini-inject niya yung smoke sa loob ng tuna. Hindi doon sa kabila. Hindi ganun na kanyang curing method. Okay? So, that's it. So, my time's up. So, thank you.
So, thank you, Attorney Hechanova, for giving us an in-depth look at the practical aspects of intellectual property law and how it ties into fostering innovation and protecting ideas in this fast-paced digital economy. So, we would like to acknowledge the 139 online participants. Thank you for attending this LTIO series today. Moving forward, our next speaker is a certified patent agent, having passed the 2009 patent agent qualifying exam administered by the European Patent Office and intellectual property
IOU FMDS para sa invitation na maging isa sa mga speakers ngayong hapon na ito. And I am privileged to discuss our programs and ano yung mga prospects ng commercialization of technologies with intellectual property rights. And this is a paki-slide na po natin. Okay. This is just the overhead picture of our office at Los Baños, Picard, DOST Picard po yan. Anyway, ang Picard po ay isa sa mga planning councils ng DOST, and we are the ones in charge on agriculture, aquatic, and natural resources research and development. Yun. Ang technology transfer and promotion division naman po ng Picard ang in charge para sa transfer ng mga technologies na nade-develop ng members ng R&D community dito po sa agri-aqua sector natin. So I am going to talk about the challenges and prospects of commercializing technologies with IPRs. Yun. Next slide, please. Down, sorry. Ako po si Noel. Skip ko na po itong introduction. The advantage of having to present after the two speakers, wala na po akong definition of terms, bahala na ang ating mga naunang speakers. But what I am pointing out in this slide are the challenges that I have recognized noong 2016 when I presented in Malaysia in one workshop hosted by FFTC. And this includes the low level of funding. Some of them are still present and felt up to this point, but we have acted upon on some of the other aspects. Low number of researchers, low level of scientific and technological breakthroughs, the culture of innovation in our institutions, yung mindset natin, yung need for the boosting of capital, human capital, low public commercialization opportunities hindi po ganun kataas nung 2016, and of course kukunti po nung time na yon. Parang sa agri-aqua sector, dalawa lang po ang nakita ko na merong commercialization agreements. It's really not a mature ecosystem at that time. And sabi nung Technology Transfer Act, ito hindi nabanggit kanina ng previous speakers, ang DOST Picard po as a government funding agency should monitor the effectiveness of IP protection and commercialization of government-funded technologies. So, at kung ang isang university or R&D institution ay walang kakayahan, we should provide alternative solutions para ma-address yung need for IP utilization. And because of that, DOST Picard established the DOST Picard Innovation and Technology Center. It was soft launched in 2016, and then our programs started in 2017, starting off with the intellectual property and technology business management. Ito po yung tech transfer offices. So nag-umpisa kami sa 10, we established and strengthened our IPTBMs. Sinabayan din namin ng 6 na technology business incubators. Nag-umpisa, we started with 6, and then we increased our coverage until we reached 51 in 2021 of IPTBMs and 22 for ATBIs on the same year. Meron din po kami mga ibang programa na ginawa. Ang isa dito ay yung related to the Innovative Startup Act discussed by Attorney Medrano earlier, we established the Startup Grant Fund under the as part of the mandate of the Innovative Startup Act. And so, and then from all the learnings from 2017 hanggang 2021, we tried to consolidate all our efforts and focus on regional approaches. And so our regional program covers 14 regions, and this is being implemented by our partners all over the country. And we now call them the Regional Agri-Aqua Innovation System Enhancement Program. So what are the activities involved in this? So there is a massive and comprehensive capability building initiatives on IP management, that's 15 days, technology commercialization, 15 days, technology promotion, 10, and if you're going to start a spin-off or a startup, meron kaming agribusiness mentorship series, 10 days din yun, or 50, yeah, 10 days. So, ang ating ay umabot na sa 94 IPTBMs, 25 ATBIs, 14 regional knowledge management hubs, and 14 agribusiness hubs. Ito po yung mga agencies involved in the implementation of the Regional Agri-Aqua Innovation System Enhancement. I would like to point out that there is a big brother, small brother relationship within the regions, kasi yung iba ay mas capable at yung iba ay mga bagong entrants pagdating po sa larangan ng intellectual property management. So this is how we set them up, and through the years, ito po, since 2022, ito yung mga nagawa natin. Ang isang importante dito sa mga IPTBMs nito at saka sa mga agencies na involved under the RACE programs is the crafting and approval of institutional policies, IP policy, a technology transfer protocol, and all of them are now crafting the spin-off policy. But of course, I would like to recognize that our capability building initiatives are conducted together in partnership with the APP. The 878 graduates of the master classes and mentorship series that we have conducted are building blocks now of the commercialization opportunities that we offer the agri-aqua sector. Nakipag-partner din po kami sa mga iba't ibang trade groups and business groups para po sa kanilang mentoring and other types of assistance. Pagdating naman po, noong 2016, historical applications and grants ng mga patents, less than 500 ang mga institutions sa Pilipinas combined. Sa ngayon po, in several years, they are now able to file on their own the patents and applications, and the slide reflects how many have been granted. So we can now boast that our local partners and our technology transfer officers are capable of managing their IP, recognizing which ones are patentable, and shepherding them towards commercialization and approval of the applications. And sa ngayon po, meron na tayong 90 technologies that have been commercialized, meaning meron ng technology licensing agreements. From dun sa mga bilang na aabot lang sa mabibilang natin sa daliri natin, we now have 90. Of course, wala tayong unicorn companies pa dyan, but papunta tayo doon siguro. Now, hindi po namin sinasabi na solve natin yung problema. Meron pa din. Sa ngayon, ang ating level of agricultural R&D funding, mababa pa. Actually, nasa 0.2% pa lang tayo. And the Philippines, as one of the developing countries, kumbaga, dapat daw ay 1%. Tayo nasa 0.2 pa lang. So, wala pa po tayo doon. And pagdating naman po sa relevance ng ating mga technologies, we really need to improve the prioritization of the research areas that we are going to address. They have to be industry relevant. Kasi wala na po, tapos na po tayo dun sa researcher driven. Dapat meron na tayong target na end user. Now, pagdating naman po dun sa our colleagues will be conducting researches and they are going to develop technologies, but they cannot be considered innovations unless they are adopted by the end users. Hindi po siya magiging innovation. And hindi siya magiging innovation talaga if they continue, our technologies continue to be at the low technology readiness level. So we need to conduct further research, improve on the prototypes, and provide market studies, business plan, etc. para po tumaas ang ating TRLs. And as I mentioned, kailangan po natin yung mga tinatawag namin na pre-commercialization services. Pag nag-develop ka ng isang diagnostic kit, meron ba yung market study? Kailangan po nating malaman ano ang value niyan. Kailangan niya ng evaluation study, business plan, meron ba siyang freedom to operate? Meaning pagka kinommercialize mo yan, is there a risk of some companies suing you for infringement? Yun po yung freedom to operate. And then, nandun pa po tayo sa stage na pagka merong private taker or interested party, ang tagal po ng processing sa ating ilang mga SUCs or maybe a lot of our SUCs are like that. And hindi na po natin kailangan lumayo kahit po dito sa Southern Tagalog. Buwan ang inaabot para makadecide kung ipapa-license ba ito o hindi. Meron din po mga researchers pa tayo na hesitant magbigay ng kanilang mga information para fully disclose yung technologies. And ang remaining challenge pa po kasama, hindi po lahat ng institutions ay kayang i-provide yung mga documents para mag-secure ng fairness opinion report, which is a requirement para magkaroon ng technology transfer through licensing agreements ang isang government funding technology papunta sa isang private agency. Kailangan po merong FOR and challenge pa po ito ngayon. They remain to be a challenge. And we are not yet so sophisticated. We are still on the licensing mode. Meron na po sa Malaysia, nakita ko yun 10 years ago, 9 years ago. They have outright sale ng technology. Hindi licensing, outright sale. Parang bang kung baga meron kang auction, kanya na yung technology. Wala pa po tayo dun sa stage na doon and very few pa po sa Agri-Aqua ang merong joint ventures. And there are still challenges when it comes to translating from bench scale, lab scale to pilot and semi-commercial scale ng ating mga technologies. Ito pa ang isa na dapat siguro maganda din i-consider ng FMDS. Paano po ba ang mga paano ba mag-secure ng mga regulatory requirements or paano ba pumasa sa mga regulatory requirements ang iba't ibang klase ng technologies? Iba-iba po yan. Ang diagnostic kit, hindi mo alam kung sa animal, hindi mo alam kung sa BAI o sa FDA. Ang biofertilizer, kung BAFS pa yan o sa FPA. Ang nano biofertilizer, ganun din. So, ito po ang mga kailangan nating malaman na mga requirements. Hindi po tayo makakapag-commercialize in large scale kung wala yung mga approval depende sa klase ng technology. And marami pong ino-offer na funding support ang gobyerno pero hindi fully disseminated yung information. Marami ang available. Meron sa bangko, meron sa DOST, sa DTI, but these are not well disseminated and appreciated by our MSMEs. Tax breaks and incentives, kailangan din po yan, lalo na kung tayo ay nag-uumpisa pa lamang as adopters of locally generated technologies. Available po yung mga tax breaks na yan and kailangan nating maipaalam yan sa ating mga kasama. But what do we have in place? So ano ba ang prospects? Kami po sa DOST card, nire-require na namin kung magsasubmit kayo ng isang technology generating proposal, there has to be a prior art search report or analysis dun sa rationale ng inyong proposal kung tech generating. And then dapat meron kang tech transfer roadmap, communication plan, ano pa yung isa, commercialization plan. Kasi ang pagpopondo po namin ngayon ay hindi lamang dun sa coverage ng hinihingi yung pera. Kailangan makita namin hanggang saan namin yan susuportahan. End-to-end ba? So dapat kung 10 years yan, alam namin kung saan kami papasok. And I think this should be adapted as a good or best practice pagka magpopondo tayo ng iba't ibang R&D projects na technology generating. There has to be a plan for the final adoption. Hindi lang sa hanggang research phase lang. Meron na rin po kaming naging initiative na yung ilang researchers natin, may kamahalan po yung magkaroon ng certified valuators. So meron na rin kaming effort dyan. We initially funded the certification course of 8 representatives of different regions. And then, yun nga po nabanggit ko kanina, yung approach namin hindi na lang institution-based, kundi region-based. So we encourage our regional partners to shepherd the others, the smaller universities, para naman sabay-sabay silang matuto dito sa IP management and commercialization. And yun na nga po, yung mga institutions na natulungan nung ating race program, plus yung capability building initiatives na ginawa natin para sa kanila, doon po kami very upbeat. Kasi nandyan na yung capacity. Ang kailangan na lang po natin ay ma-improve yung ating mga technologies na generate. Ready po ang ating mga technology transfer officers dito sa iba't ibang ahensya. And of course, ang gusto lang po namin sabihin dito is that we are very thankful with our partners in the regions and all over the Philippines kasi yung pong mga nireport ko kanina ay hindi mangyayari kung wala yung strong partnership na yon. And we have to continue innovating and funding researches. So kung dumadami po ang local technologies na na-adapt at nako-commercialize, we were thinking and the law is anticipating the Technology Transfer Act that this would further spur innovation and R&D activities in the country. And of course, kailangan lagi na hindi kanya-kanya ang gagawin natin. We need to partner and collaborate with each other, with all those relevant organizations that are working on the same areas. And having said all that, we may have capacitated and readied the ecosystem for further commercialization of locally generated technologies, pero ang dami pa po natin gagawin and we need the help of all like-minded institutions to further our journey towards commercialization of agri-aqua technologies. Magandang hapon po at maraming salamat.
Thank you, Director Katibog, for highlighting how the public sector initiatives drive technology transfer and commercialization. So I hope you are still with us as we have more insightful discussions to come. Now, allow me to introduce our fourth speaker for this afternoon. She holds a Juris Doctor and a pre-law degree from Arellano School and De La Salle University. She
know if I am clearly heard.
Yes, ma'am.
Thank you. Um, so, uh, so again, good afternoon. And first and foremost, I would like to thank the University of the Philippines, the Faculty of Management and Development Studies for this invitation. In behalf of the Director General, Attorney Bridget da Costa Villaluz, I am deeply honored to represent the IPO field. Allow me also to greet some of my colleagues and people that I know that are present here in this forum. Of course, earlier you heard Attorney Beth Medrano. She was formerly the Director of the Bureau of Patents of IPO and currently the Commissioner of the Commissioner in Philippine Competition Commission. Likewise, I heard the presentation of one of probably the most distinguished practitioner in IP, Attorney Edith Casanova, and she was recently awarded in our IP month as one of the most number of examination and filings in trademarks, and I don't know if in patent as well. But Attorney Casanova has been practicing IP. So, and later on, we will be joined also by one of my colleagues in the IPO, Ms. Rosa Fernandez will be here to answer your queries in the question and answer portion. So without much ado, of course, allow me also to greet our participants. We have 140 plus participants right now, and thank you for your attendance today. So let me now start my presentation. Okay, so I will be talking about the registration process in intellectual property rights here in the Intellectual Property Office of the Philippines. So, to talk of registration, and in many contexts, registration is practically or signifies the protection. So, in many government agencies, for example, the Securities and Exchange Commission, you have the PSA, the DTI for a business name, it all involves registration. So similarly, in the Intellectual Property Office, there is also the kind of registration, and this is the registration of the IP rights or the IP assets. Let me start with some brief question and answer. This is actually one page because of time constraint, just to give emphasis on the need for registration. So the first question is registration of IP rights or IP assets mandated under the law? Well, Republic Act 8293 is the Intellectual Property Code, and it provides that there is no specific mandate or there is no specific compulsion for any person to cause the registration of their IP assets. It is not strictly mandated, but it is highly encouraged. And often necessary, this is for the owners to be able to secure protection through registration with our office, the Intellectual Property Office. So what are the benefits of registration? I lump it up into two basic benefits. You have the legal protection and the enforcement, and of course the business and economic benefit. So if you talk of legal protection enforcement, it means that once a registration is secured, there is a grant of exclusivity of rights. And when you say exclusivity of rights, the owner or the registrant has the exclusive ownership over that asset, that IP asset. And this is to the exclusion of third persons, to the exclusion of anybody who wants to copy, to imitate, to tolerably produce or imitate or reproduce that IP asset which is validly yours by reason of registration. Secondly, if there is registration, then it affords legal action or it provides for legal remedies. We all know that there are so many IP cases that were already decided by Supreme Court. As a matter of fact, Attorney Chanelba earlier presented to you some of those cases. You have the case of Lacoste and Crocodile, That is one of the cases that I decided as hearing officer. When I was still with the Bureau of Legal Affairs, and one of the most recent decisions also in trademark cases. She also presented to you, just to show you that legal action is really afforded by the owners of cases as regards copyright infringement. So these are the actions that may be taken by the owner. The proceedings with the Intellectual Property Office is quasi-judicial in nature, which means that it is very similar to a court proceeding, and provisional remedies as well as all other prayers, the reason of the damages may be fully granted in the decision that will be rendered in the cases that will be filed within us. So let's go now to the business and economic benefits. Of course, in the discussion of Director Katibo, he also mentioned about market valuation of these businesses. There's also the increase of market valuation of business if you have a registration of your IP assets. Allow me to mention that the Intellectual Property Office right now has programs referring to this valuation of assets. We all know that in terms of valuation, it is very hard to secure, not only because it is costly, but it is not practiced in a large scale. But there is a question that I clicked in the chat box, a question referring to IP rights being an asset but not reflected yet. Why is it that it is not reflected in the financial statements? That is a very valid question. That is why the Intellectual Property Office now has this program for market valuation. We underwent several trainings with the World Intellectual Property Office to educate and to enhance the knowledge of some of our colleagues in the IPO for possible valuation services. Because at the moment, if you want to secure the valuation of your IP assets, the clients would go to an accounting firm for valuation, or to DOST, which is also a good office which I believe provides for this kind of service. But as an IP office, we also need that we have to learn this valuation and to give service and benefit also to our stakeholders. Now, going back for business and economic benefits, we all know that once an IP asset is registered, it also gives financial reward. Because like any other property, being an intangible property, but very much a kind of property, it can be subject of sale. It can also be subject of assignment, transfer, commercialization, licensing, and franchise. In other forms, it can also be subjected to inheritance. Just to give an example, when Mang Inasal was purchased by Jollibee Corporation, it was reported that the total IP-related assets after the proper valuation was more or less 2 billion pesos. So this is the amount of this IP-related, and this includes trademarks, copyright, and patent IP rights. So this is an example of a financial reward. Moreover, it can also be used as security and collateral for loans. It can also build brand recognition and encourage innovation and creativity. So these are the different intellectual property rights. It was already shown to you earlier. These are actually enumerated under the IP code. So just to show you an example, if your product, for example, you have a rubber shoes, there are several IP rights. You have a trademark for your rubber shoe, which is the name and symbol of the shoe. You have patent if there are certain improvements or any improvement to the product, for example, in this case, for performance and comfort. There's also the industrial design, which is the design of the shoe. And there is also a copyright protection in terms of artwork and audiovisual creations used to publicize or to advertise the product. Okay, so step one, let's go now to the process. This is general. For step one, we first want to identify which assets we want to be protected. So I mentioned that a while ago. So it could be a trademark, which must be distinct, and it has a term of protection of 10 years, and it can be forever, provided, of course, the procedural requirements are followed. So these are the example of trademarks. For patent, it could be an invention which has a definition provided, of course, by RA 8293, and these are the elements. And the term of protection for patents is 20 years. Okay? So these are just example of patents, and that includes even in pharmaceutical products. Utility model is also known as the petty patent. So these are the elements, and for the term of protection for a utility model is 7 years. It is non-renewable. And just to give you an example, these are some of the utility models which are protected not only in the Philippines but also in other countries. You have chopstick with fan and raincoat umbrella. While these are new in terms of their functions, such that they qualify as a utility model and was issued registration. And you have also the industrial design, which also falls under the law on patents. Industrial design, on the other hand, practically protects the aesthetic creation or the features, the visual designs, or the appearance in whole or in part of the product. So this may include design as to the lines or the colors of the product, also the shape, the texture, the contours. For example, you have there the bottle of a beverage, a soft drinks, and even ornamentation. So for the term of protection, that's 5 years, and it can be renewed up to 15 years. So that's a maximum 15 years or 2 times renewal. So that's an example. You have the slippers, which is a product exhibited in the Design Center of the Philippines and designed, of course, by the same organization or same office. And of course, you have the copyright. When you talk of copyright, this is quite different because in copyright, there is already the automatic protection or protection afforded by the law from the time a copyrightable work is created, as distinguished from trademarks and patents, whereby there has to be the registration for you to complete ownership and be protected as such. So that's the only difference. So these are some of the examples. And in terms of protection of copyright, the term is lifetime of the author and 50 years thereafter. And it depends if the copyrightable work is jointly owned or is owned by an organization or an institution. But the general provision of law or the general rule is that copyright is protected from within the lifetime of the author and 50 years thereafter. Okay, so step 2, it is advisable that you make the pre-filing research. You can search the website of the IPO field, and we have there under services. We also have e-services, and you can make the research whether you want a trademarks, patent, utility model, design, and that is available now on the screen. You can also capture that, or you can go directly to the website of IPO field to conduct a pre-filing research before the actual filing. That will, of course, save you time and expenses. Next, you now have to file your IP application. In the filing of the IP application, this is done online. We are fully automated. We are available 24/7, including the payments. We accept payments through Paymaya, DragonPay, and even the DPP. So again, on the screen, you can show the QR code. And this is also available, of course, in our website. Now, let's talk of the process very briefly because of, again, the time constraint. I'll be very fast. Before the trademarks, first you have to file and you pay the appropriate fee. then it will be subjected to examination by the Bureau of Trademarks to our examiners. We have now 25 examiners to check or be assigned of your trademark application. As a matter of fact, last year we received about 45,000 filings. That's for the entire year, but with only a handful of examiners, we only have 25 examiners. Thereafter, there is the registrability report that will be issued by the examiner when the applicant has the time to make to file his response as to the findings of the examiner. So if after the allowance of the examiner, there is a notice of allowance or the first publication, if there is no opposition on the part of any third person who feels damaged by reason of the registration or the supposed registration, then it will be registered. And there's a second publication and the issuance of the certificate of registration, which is also through online, provided of course there's a request for the physical copy of the certificate of registration. However, going back, however, if there is a third person who wants to oppose the proposed registration of the mark, then an opposition case will be filed and the jurisdiction will transfer with the Bureau of Legal Affairs for adjudication. Okay? So it is necessary that there is a registration because the law itself provides that the rights in a mark is acquired through registration made validly in accordance with the provision of this law. As a matter of fact, there is a related provision to that saying that the issuance of the certificate of registration is a prima facie evidence of this registration, the ownership, and the exclusivity of the rights. So that's the provision of the law, and that's the basis for the need of anyone to file the registration of their trademark. Let's go now to patent registration process. For the patent registration process, there are two steps. This is as regards invention. So you have the formality examination stage and the substantive examination stage. All in all, this will more or less the amount that will be spent by the Bureau of Patents is about 38. So later on, Ms. Rosa is here from the Bureau of Patents to give you a more substantive explanation if you have any questions on that. But the filing date to 18 months would require a formality examination whereby the claims and the other requirements as required for under the law will be checked by the Bureau of Patent Examiner. And after that, there will be a first publication and a request for substantive examination will be done in accordance with the elements as provided for under the law if the patent application suffice the elements provided for under LA 2293. After which, there's a grant of patent for a second publication. I also provided here some of the important circulars necessary if you need to file an application for patents. And this includes the publication of patent applications, special publication cases, the rule on confidentiality, and the possible filing of a third-party observations if there is a possibility that any person would submit an observation on the patentability of the applied patent. So similarly, I also provided here the important requirements or the possible events that would happen from months 18 to 24. And this is actually, again, the substantive examination phase of the patent application. So again, the term of patent is 20 years. When the patent becomes void, if annual fees are paid or if it is cancelled under the IP2 regulations by the Bureau of Legal Affairs. Finally, let's go to the copyright registration with IPP. I mentioned earlier that as distinguished from registration in trademarks and patents, sa copyright, automatic ang protection dyan. In fact, it is not registration which really gives that protection. No? When you talk of registration in copyright, it's basically a fact of ownership. This fact of ownership becomes a public record by reason of registration. This also provides a constructive notice, a legal notice that this certain work is copyrighted or is registered under the name of whoever filed for that application. It is also a chain of title for purposes of tracking. Sometimes if there is no main owner, then it becomes a secondary evidence. It becomes the evidence, the reason of that registration issued by the IPPL. Although by law, it is the National Library who is the depository of the copyrightable works. Okay, so here I am presenting the copyright registration process, wherein we can search again and go over those links in the IPOPL website. So this is very helpful because again, this is online. We can just download the form through the IPOPL website. So you can search it in the services section and go to copyright registration and everything will be made available. So you can see this copyright form. This is downloadable and just fill it out. And these are the necessary requirements, especially in terms of that box providing for the name of the individual copyright owner or the owner if the owner is an institution. Okay? So in addition to that, these are all the boxes that should be filled up. There's also disclaimers for authorship claim in terms of submission of the works and other requirements necessary to determine ownership, including the use or the any GIA artificial intelligence participation in the work. Okay. Because that would spell the issue of ownership. It would talk about ownership. And finally, you have here a portion for recordation of assignment and for possible mortgage agreement application. And also an application for whether you agree or disagree as to data privacy issues in accordance with the Data Privacy Act of 2012. So you see now the documents necessary, and it's also attached in the said form the classification of works. You can see what works are can be copyrighted or can be protected or subject of registration certificate of the copyright. And insofar as the fees are concerned, it is also provided there how much you will pay. In terms of trademarks, you can, or in patents as well, you can also view the amount of fees or the schedule of fees in the IPO field website. Okay, so again, for copyright registration, we can define on requirements to copyright underscore registration at ipofield.gov. The IPO field website is user friendly and you can access it at any time. Probably this is spells now the process for registration certificate. Again, for the certificate of registration with the copyright, it may be sent to courier if there is a request, but the certificate is usually sent via email. So thank you. I hope that you have learned the registration process very briefly, and thank you for your attention.
So thank you, Attorney Badiola, for walking us through the IP registration process. It's helpful to see how the formal mechanisms work, protecting innovations and encouraging inventors to bring their ideas to life. continuing our discussion, allow me to introduce our fifth speaker for this afternoon. She is a DOST SEI scholar with a PhD in physics from the National Institute of Physics, UP Diliman. With nearly a decade of research experience, she has published in peer-reviewed journal and mentored undergraduates and graduate students at the Plasma Physics Laboratory. She transitioned to corporate R&D as a staff new product introduction engineer at a global solar manufacturing company, where she led materials qualification projects and managed Yes, we can hear you po.
Okay. So, thank you for the invitation. Thank you, Dr. Leo. I apologize for the there physically, but I hope the attendees will be able to learn from what I have to share. So, the topic assigned to me was IT management in government, R&D, SMT organization. Next slide, please. Okay. So the presentation would be as follows. I will be discussing at least the current landscape of the ecosystem and why management is not just important but critical for its success when we're examining legal and policy frameworks, identify KPIs and the roles and the renewable the IT management life cycle and from initial disclosure due to commercialization and then revenue, getting revenue, and I'm sharing a success story about one of our researchers, and then we'll move into challenges and opportunities based on this case study. So next slide, please. Okay, so I don't know if there is the technology development stage. Innovation is not it's not one step. It's a complex journey, often depicted through the TRL or the technology readiness level. So as you can see in this slide, there are actors. These are the ones that are the key performers. We can call them that. And then there are funders. Usually they are involved in the process, and then most of the time the process would decrease or we have limited resources. So not all research would travel or complete the whole TRL scale. The GII mentioned this time by our previous speakers, the Innovation Index tracks how well companies move into those stages, meaning not just inputs, meaning funding, but also the outputs like patents or commercialized products. So countries that excel in GII, meaning those hierarchy, they have full support every step. The Philippines being at 53, pwede na. Okay, so next slide please. As mentioned by Director Katibog a while ago, not all research or not all R&D were able to be commercialized. We have what we call the valley of death. This is where most innovations die. One reason, lack of resources. Another, lack of interest. Again, so resource, human resource, lack of interest of the, or maybe all the technical sides were validated, but there's a problem in the market. The market is not ready for your technology. That's why it's not enough to have the technology push, the innovation. You need to consider always the market. So, para may bibili, kung gusto mo mag-commercialize, may bibili, may gagamit ng product or ng service mo. Yan. And the institute where I'm currently assigned, TAPI, we do have several assistants wherein we are able to help the researchers to bridge this valley of death. Okay, next slide please. Okay, showing let us look at the Philippines in terms of global innovation context. So, okay, tumataas tayo. Meron tayong progress. And usually, mataas tayo sa output. Ibig sabihin, kahit konting resources na bibigay sa atin, ginagamit natin siya na maayos. We are able to efficiently use the resource being given to us. Kaya mataas din yung ating outputs. At isang example kung saan natin ito yung innovation output is through dito sa IT. Okay, next slide please. Ito sa innovation, I'm thinking one of the factors for innovation input with learn, which is the gross expenditure on research and development. And comparing the Philippines to ASEAN countries, Philippines is only ranked 73, and we don't even reach the average prescribed by UNESCO, which is about 1%. We are only at 0.3% there. So, kulang na kulang pa nga. So, kung titignan natin yung sectors, saan ba na-allot yung government natin yung budget for R&D? Mataas na porsyento yung economic affairs. Next is for education. So, for the past 3 years, well, in government in terms of R&D, budgeting for R&D. So, next slide please. Yeah. Titignan natin paano yung distribution ng budget ngayon, titignan by department. Number one, is a plot based on this graph, this table. From 2018 to 2021 lang po, ito yung available from Congress. BRST is at the top, getting the maximum, the largest amount for budget. The other ng BOST, pinaghatian yung maliit. But you can see yung SUs natin, State University and College, malaki din yung nila. And we can observe na eventually, as the year go by, yung pag-budget nila ngayon, kung saan nakalat yung pera, lumalaki na yung for SUCs. Although, syempre, definitely, alam natin budget cut for SUC, but still, it's bigger than what the other departments are getting. Next slide, please. So, things we mentioned doon, may BOS na is getting the bulk, the greater part of the budget for IND. We must look into yung organization ng BOST niya. Bakit important yung role ng BOST? BOST leads and coordinate the SME efforts of the government in terms of national and technology. So, BOST is mandated to provide the central direction, the coordination, and sa structuring BOST, it has an extensive network comprising of various councils, HR, then NRCP. And then service, kami, TAPI, is a service institute. Okay. Service institute, and then in others is RDI. So, and we function using using the 4 pillars as guide, which is human well-being, wealth creation, wealth protection, and sustainability. Next slide, please. Okay. So why is IPE? Why IT management matters in R&D? Because pera ng bayan yung ginagamit. Like, this is a way. Pera ng bayan we gamitin sa tama kasi pera ng bayan. So, the public is expecting to pera ginagamit, ini-invest. So, why would investment through IT management? So, listed here yung iba pang reasons. First, fundamentally, it's to ensure the protection of significant public interest, investments, even research, and facilitate commercialization, drive national development, eventually, tataas yung ating BII. Eventually, may magiging, dadami yung ating investors. So, once research nakita there's money in innovation, there's money in research, they would eventually continue doing research. Next slide, please. Next slide, please. Next slide, please. Continue in the order. Yeah. So, three key stakeholders, the DOSD, funding agencies, DFAs, research RDIs, research and development institutes. Next slide, please. Research yung nag-innovate, nagkakonda R&D, yung invention. I prefer, and syempre, naka-asteris lang si Tati na rin kasi mandated to promote and commercialize yung mga DOSD technologies. Next slide, please. Okay. So, once yung ating researchers, ano sila ng innovation, they think it has potential for IP, they need to disclose nila sa RDIs, and RDIs will be responsible for submitting disclosures sa GFAs, funding agencies, sa TAPI, and then already sila mismo magpapalaki sa IPFL. Next slide, please. Excuse me. So, generally, for ownership, generally RDIs own the IP from DFA, and possible din yung ownership nasa research agreement na rin lahat, and possibly din na feeling yung GFA or i-assume yung DMA, GFA yung ownership if the RDIs fail to disclose or protect the IP during the timeline. And in case of national emergency, if ever magkaroon ulit ng parang COVID pandemic, if kapag may nag-research about that, they can just get it kasi nga, it's a national emergency. Next slide, please. So, for IP protection, yeah, it's the responsibility of RDIs or else the PLOs, they would be supporting the IP management, licensing in this partnership. And when there are different commercialization modes, they can either license spin off PPE, public-private partnership. Next slide, please. So, ito nga, let's incentivize innovation so that researchers will think of it as a valid source of income. So, 40% for researchers, 60% for RDIs, and then yung researchers pa mag-vary pa yung mag-receive depending on the number of authors. So, yung revenue na nakukuha, pwedeng fund further ongoing activities. And then, kapag meron ka ng revenue, hopefully you'll be able to invest it and to other technology so that you could gain societal benefits and economic benefits. Next slide, please. Next slide, please. Okay. So, recently, yung sa TAPI, sa technical program, marami na ngayon yung mga private-public partnership because sila yung innovators na they are dealing with emerging technologies talaga. Medyo behind pa yun sa public, yun sa mga government research, kasi syempre matagal ang ating purchasing, biglang ito sa back. So, private talaga tayo umaasa. And sometimes we do have the resources pa for market study. So, mas marami silang ganun. So, we do encourage public and private partnership. Next slide, please. Oh, next slide, please. Yun. So, ito na, it's just a cycle. Ikot lang. So, ikot-ikot lang. Dapat lang na innovation mode getting new revenue. Next slide, please. Yeah. So, ito yung success story ni Effect M, dengue detection. It was funded by PCHRD in 2013, and eventually, tapos next, nag-apply sila sa technical and then venture funding for the configuration deployment, and then nag-loan sila for venture financing para sa equipment. And now, currently it's now being sold by Manila Health Tech, which is a spin-off company. Yung project leader to in-apply for funding sa PCHR, si Dr. Destila, is now the owner of the Manila Health Tech. So, yung mga protection namin, may trademark is others. And good thing about this, yung pillars talaga na satisfy yung for health, wealth creation, and protection kasi may items. And then sustainable kasi it would be giving jobs din sa mga employees for as well. Next slide, please. The challenges, limited awareness. The challenges, we have limited awareness na. Awareness din sa mga programs and assistance na ino-offer ng UST na pwede pa lang mag-grant. Meron ka naman e-trap and then e-attract for PCP or international publication, and meron din for market analysis para malaman saan ka, kung magpapublish ka internationally, saan lugar may market for the particular technology. And technical and galing is for those technology na superior at 5 na, so that it could reach out or they could complete the pre-commercialization stage. So, opportunities, limited opportunities, syempre, strengthen the institution, streamline the tech transfer, kasi nabanggit na mag-developer, tibog, mabagal pa rin talaga, and as much as possible, we partner pa rin talaga. Kasi yung industry, sa the university and industry, minsan hindi pa rin nagpo-connect. Hindi pa nagpo-provide ng NCR ng meeting of the arts yung kailangan ng industry. Next slide, please. Next. Bawat kasi ang PRDT namin dito kaya hindi alam yung internet connection kung stable ba. So, pretty sure anything is a robust legal and policy framework. We just need to maximize yung impact ng mga ganitong policies. Kasi we need to collaborate and capacitate para mas malaman na may alam kung pattern, paano sila. And we need to translate, we need to select innovations na pwede magkaroon ng benefits. So, parang society benefits because, as I said, we have limited resources para hindi pa ng funding kahit may funding grants. Pero we have to set priority programs or priority topics that the government is eyeing. So, that's all. Thank you.
Thank you so much for that insightful presentation, Dr. Pabeliña. It's truly enlightening to see the vital role that DOST-TAPI plays in supporting technology transfer and commercialization in the country. We are now down to our last speaker before we proceed to our discussants. She is a professor at UPLB's Institute for Governance and Rural Development.
you very much for nice presentation. By the way, Miss Nikki Velasco is a tutor in our diploma master in R&D management. Okay. So the topic assigned to me is more or less recap of the whole presentation, and we would like to say that this LTIO focus on IPR was born out of our advocacy for intellectual property rights to boost our global competitiveness. That's why the first speaker is the commissioner in PCC, no? Philippine Competitiveness Commission. And then it will bring, when I say titillate, the awareness and the desire of MSMEs as well as private industry, HEIs, in intellectual property rights management. So the advocacies, no, of course, the prime implementer of the RA 8293, pardon me because I also teach policy, the IPOFIL, particularly it's ITSUS in the higher education institutions, and now they have IP Academy, and then we have the DOST, the main implementer of the RA 155, where in all the councils, R&D institutes, particularly the last speaker came from, is R&D fellow of the Technology Application Promotion Institute, as well as societies, professional societies, where our distinguished attorney Hechanova come from, no? Association of PAQ professionals, as well as the technology transfer professional. I think we have representative from one of their members. Let's discuss it. Okay, so IPOFIL is just almost all my slides can be accessed publicly, so I don't need to have a copyright or permission. So IPOFIL Academy right now, I think I've received via email. They have a boot camp for the undergraduate students as well as lawyers, and you know that patent no is a really domain of lawyers. But right now, I know some academician in the National Academy of Science and Technology are also from science to patent agent. No, we have just identified some of our academicians there. So they offer the IPOFIL Academy, IP Academy, offer basic seminars, intermediate advanced training, certificate courses, and professional development trainings, and others. You just write them, no? You just write them. If your institution or you personally, as a professional, would like to avail of their services. Now, DOST, I said RA 155 is Technology Transfer Act of the Philippines, in 2019 had this omnibus intellectual property management protocol, wherein they set up technology transfer units, technology assessment and transfer business. I'm not really sure, but of the exact units in each of its agencies. So we also follow this in the HEIs, like where I come from, UP Los Baños. Again, part of the DOST family is Philippine Picard, where Director Noel Catibug comes from, as well as other councils like PSHERD and PCRD. Now, pioneering the dissemination among regions, as previously mentioned, is the master class of PCARD with assistance of the APP of Dr. Where the president is Attorney Edith Genova. So we have the master class as well as the RACE program, among others, because there are caravans, exhibits, they have so many. Now the UP system, of course, the UP will not be left out, no? The UP system with each campus has the TTBDO, tongue twisting, Technology Transfer Business Development Office. Of course, I'm featuring UPLB. But each TTBDO in the campus have its own website, no? Love my own, UPLB. So in UPLB, we have our access, IP management, commercialization, business development, and promotion. So there are lots of activities in technology caravan, boot camp. Now, again, besides the TTBDO, which is really a service unit, in our academic programs, particularly in technology management and research and development management, we incorporate IPR. And foremost is UP Los Baños and UP Diliman. UP Diliman has the Technology Management Center. UP Los Baños since 1980 is offering R&D management, and one of the topics there, current legal issues, no, regulatory environment, is R&D management. So when we crafted the ladderization of diploma to master in R&D management, we engage our partners in different associations like PhilArm. We have a speaker, no, from PhilArm, the president of PhilArm now, from Marinduque State University, and of course TMC of UP Diliman. So UPOU is offering two programs, diploma in and master of R&D management, and that is a multiple exit, multiple entry muna, multiple entry and multiple exit program. Okay, it was just before actually, when the Board of Regents approved of MRNDM, it's COVID time. So it's really difficult for us, but we are productive even during COVID. And the first offering of this Master in R&D Management was the first semester, 2021-2022. So UP Diliman has TM255 legal issues, one of the courses, and IPR is one of the legal issue being discussed there. UPOU has a specific course in IPR in R&D organization. So I encircled the last one. Please take note of that. R&D 253. And that's the course site. You cannot access that, exclusive for students and faculty and the program chair. But everything else you can access in the World Wide Web. So right now, handling the course on RNDM 253 is none other than Commissioner Beth, no, Medrano, and she's the anchor, and I'm assisting her for this course. So what is this course all about? It's a 3-unit elective course which can be taken by any UPOU student in graduate program, master or PhD, and can be cross-enrolled by UP students in other campuses. And then this one, when we have presented this to the to the academic committee, that time, no, they wanted this to have to be open to all, no prerequisite, no COI, and as an elective, not a core course. So everybody in the higher education in UP can take this course. The question is, what about non-UP graduate students? What about individuals with no baccalaureate degree? Medyo masaya siya nung college, hindi siya nakatapos, engineer, o lawyer, ganyan, o business person. So what about them? What about those who are still equivocal or undecided to pursue either the diploma in or Master of R&D Management programs? What about the organizations, mga MSMEs, mga industry, yung kanilang commercialization or technology marketing department, which aims to strengthen professional development of their personnel on IPR. What about credits in the renewal of professional license? Di ba required na ngayon na with the continuing education, those with PRC license should take credit units in training programs or professional learning events. So, micro-credentialing IPR in UPOU, this will be in the offing, and the offering will be fully online, and according to UPOU's mandate to provide opportunities for alternative access to quality education. So both undergraduate and post-baccalaureate. Now, this is also in compliance with RA 10650, Open Distance Learning Act, which provides for an expanding access to educational services by institutionalizing open distance learning in the Philippine higher education. So we, the UPOU, actually I'm teaching in 2 campuses. The residential at UPLB, where I am, that's my mother unit. And in UPOU, where I teach since the beginning of UPOU. Kaya I'm as old as UPOU. Yun na lang ha, not my real age. But the age of UPOU, matanda na rin. So in view of UPOU's strategic area, performing the major functions of a university where the action point is micro-credentialing and stackable credit towards a degree. What is micro-credential? So nag-Google, ang galing ng AI. Ang dami kong natutunan sa AI. And many of our students are really guilty of using AI in the submission of their assignments. So what is micro-credential? So micro-credentials are digital certification like digital badges that verify a learner's attainment of specific knowledge, skills, or competencies after completing a structural learning experience. What are these? It's features, digital and verifiable. So if an employer wants to verify the qualification of an applicant, you can digitally check it out. Focus and targeted, research project implementation, on creativity and innovation, on now intellectual property management. So you can choose the specific topics. Flexible and timely, what are the current needs of a professional? Industry relevant, this is more of demand driven, no? Not supply push, of the industry, whether in manufacturing, in the R&D, and of course for the academe, stackable and portable. And the benefits, enhance employability. But if you talk about MSMEs, we should not be all employees. We should be employers ourselves when we promote entrepreneurship. Personalized learning, career advancement, cost effective. You don't need to dress up or go, travel to attend or rent a condominium or a dorm to study. No? You can study anywhere, anytime, any place. And lifelong learning. Mind you, in UPOU, we have, as young as I am, still enrolled in various programs at UPOU. I'm already senior citizen. Yeah, I'm as young as I am. So UPOU roadmap in micro-credentials basically aim to equip Filipino professionals through lifelong learning. So last year it relaunched its micro-credential program and asset platform and dedicated one international conference in open distance e-learning just for micro-credentialing. So what is Ascend is really a portal. We have several portals at UPOU. And Ascend is one of the portal which the micro-credential courses will be lodged. So coming soon, wait for this. The micro-credential courses the word S, no, the letter S there, no. It can be a series of micro-credential courses for IPR at UPOU in partnership with IPOFIL, DOST, APP, and other organizations. So, for those interested in micro-credential course for IPR, why not at UPOU? We will be waiting for your email, or in our Facebook page, send us a message. If you're going to send us email, Prof. Leo here, who's the new, hindi na new, no? The RNDM Diploma and Master RD Managed Program Chair. So note this, no? Screenshot the email address. And with that, ladies and gentlemen, who are about 150 in Zoom, and two couple of hundreds in Facebook. Magandang hapon po sa inyo at salamat po ng marami. Pagpalain po tayo.
So thank you, Dr. Reyes, for contextualizing the role of intellectual property management in R&D and innovation strategies. It's inspiring to see how this connects to our larger goals of inclusivity and sustainability. Now, we will have the response and insights from our discussants about the presentations this afternoon. Our first discussant is a faculty member at the Department of Mining, Metallurgical and Materials Engineering at UP Diliman. He earned his BS in Chemical Engineering and MS in Materials Science and Engineering degrees from UP Diliman. He holds a Doctor of Engineering degree from the Shisha University, Japan.
I'd like to thank Dr. Leo Rosario for inviting me and be one of the discussants in today's activity. So I have sort of trying to understand what discussant is, but I hope I will be able to deliver what is expected from discussant. No? So as always, we get a lot of beautiful insights, no? Very insightful presentations earlier, and I'm trying to synthesize this and add to the discussion on today's topic. So what I would like to contribute is that the speakers emphasize the importance of intellectual property, but acknowledge that there are different dimensions of intellectual property, especially in the management. No? And then I would like to emphasize that it may not be rarely discussed this afternoon, but there is also a big role for human capital. And that is, I think, what we should also address, not just the technology itself. So I think the central role of human capital in bridging the gap between early stage research and market adoption. No? In our college, in the College of Engineering in UP Diliman, although we do a lot of technology related research, but we want to emphasize also that technology transfer is difficult, no, or is impossible if there is no knowledge transfer. And if there's no there will be no knowledge transfer if we have people transfer. So our college tried to fill these different aspects. No? So we want our students, our graduates, and so on to bring the knowledge to the market or to the industry. So from my experience also from the technology transfer office, it's becoming difficult to get licenses because some industries are not ready. there are some markets that are not ready. So one option of our inventors is to spin off. Now, spinning off is also a different aspect because as some of our startups no, in UP Diliman, when it comes to the market and financial aspects of doing the business, they call that the dark side because we are trained as engineers, not as financial analysts or marketing people. Of At the heart of technology transfer lies not just the innovation or the patent, but the people, right? So you have researchers, technology managers, legal experts, and entrepreneurs who interpret, refine, and adapt these inventions for practical use. The value of IP is ultimately realized through the capabilities, experience, and strategic insight of human capital managing it. Now, there was a discussion on TRL or the technology readiness level. So when we talk about low TRL, the early, often fragile stages of innovation, this is where human capital is most essential. Many promising technologies stall at TRL 3 or 4, not because the science is flawed, but because the ecosystem lacks individuals with a translational mindset and skills to develop and de-risk these innovations toward maturity. This includes people who can communicate across disciplines, align research with real market problems, and structure IP portfolios in a way that attracts partners and investments. In fact, our technology transfer officers, they have to assume different hats. No? They can be the technical person, they need to provide some legal support, and then they have to do the marketing part of the technology. So you have different skills involved in transferring these technologies. In technology transfer offices and university industry interfaces, we often focus on patents as the currency of innovation. But without mature technology packages and teams capable of navigating regulatory, scale-up, and integration challenges, IP remains under-leveraged. Enhancing capacity building within TTOs with professionals who understand both legal frameworks and sector-specific commercialization pathways is key to converting low TRL technologies into mature, investable propositions. Moreover, trust from industry is a function of not just a robust IP, but also of demonstrating capability in delivering scalable and reliable technology solutions. Industry partners look for maturity not only in the technology, but in the people and institutions behind it. Creating trust means developing a consistent track record of successful collaborations, clear IP, ownership models, and transparent valuation methods. Just yesterday, we had an IP clinic with one of our law firms in UP Diliman, and this is one of the technologies that I did research on, and we actually discussed our approach to the IP protection. So we discussed patents, industrial design, and even what they call utility model. No? So hopefully, and together with our industry partner, because this is an industry funded project, so hopefully our industry partner will continue the adoption of the technology. Finally, we must acknowledge that different technologies face different maturity trajectories. Digital technologies may scale up rapidly, while materials or biomedical innovations require longer gestation. In other words, technologies are not created equal. IP strategy should be adaptive and aligned with this life cycle, factoring in when to patent, when to publish, and when to partner. Another important trend shaping the IP landscape I'm not sure if this is true, but you can tell me. But when I attend ITSO gathering, no? So there is this, I find that there's a rise of utility models. So especially in emerging economies. Now these petty patents often offer quicker, cheaper protection for incremental innovations. These are particularly common in applied research and engineering solutions. While utility models can accelerate the protection of early stage technologies, they also shift the burden toward rapid prototyping, documentation, and enforcement, forcing the need for human capital technical of. Sorry. So, however, utility models also tend to reflect the readiness of innovation, but not necessarily its maturity. They often precede thorough validation or market testing. This raises two critical issues. One is that they demand even more from the human capital involved in managing them, quick decisions, fast documentation, and careful alignment with product development. And second, they can sometimes signal fragility in the underlying technology when evaluated by industry, especially across international markets. However, we must also recognize that utility models have limitations. Shorter protection duration, often lower thresholds for novelty, and limited international enforceability. This can raise concerns for multinational firms evaluating whether to license or to invest in technologies based on utility models. Now, in our office, we try to file patents. We try to consider patent filing rather than UMs. Why? Because we find utility models to be novelty destroying. So when the technology continues to develop, it becomes difficult to apply for IP protection. Thus, human capital becomes essential in making strategic decisions. When to use utility models versus full patents. How to align protection strategies with technology life cycles, and how to communicate these nuances effectively to potential partners. Therefore, it is vital to develop strategic judgment on when to use utility models versus full patents, based not only on cost or speed, but on the expected maturity of the innovation, its market potential, and the readiness of the ecosystem to scale it. I would like to add also the micro-credential IPR course of the proposed course. No? So I think a lot of our, not just the technology transfer officers will benefit, but even our researchers. In UP Diliman, we have also technopreneurship courses, and we add topics on intellectual property because we have to let our students, both in the graduate and undergraduate programs, that in order for you to move forward with your technology or invention, then you have to have that protected or ensure that you don't infringe existing patents. No? So we have to check also the freedom to operate. So hopefully this course will be realized, and I think some of our students will be interested in enrolling the course. In summary, whether we're dealing with patents or utility models, early stage or mature technologies, the differentiator is rarely just the IP itself. It's the people and the processes around it. Investing in translational skill sets, building institutional credibility, and fostering trust across academia and industry is key to unlocking the true potential of our innovations and strengthening global competitiveness. Thank you very much, and mabuhay kayong lahat.
Thank you, Dr. Vasquez, for that insightful discussion. We will now proceed to our second discussant. Our second discussant is an intellectual property rights specialist 5 and the division chief of the Chemistry Examination Division of the Bureau of Patents IPOFIL, where she received the Best Supervisor Award last December 2024. On top of her regular functions, she is actively involved in the developmental programs of BOP, providing technical services to IP patent filers. These services that are extended to local inventors, researchers, and scientists from the academe include, among others, customized patent drafting workshops and the conversion of scientific studies and researchers into patent applications. She also represents the office in various interagency meetings and international conference on IPR and IPR-related subject matters such as traditional knowledge, genetic resources, traditional cultural expressions, and plant variety protection. Let's welcome Ms. Rosa Fernandez. Fernandez. All right, so for our next discussant is an industrial engineer and MBA with extensive experience in project management. He is also involved in technology business development, being a co-founder of Arnichem Corporation, a agri-biotech company. Arnichem Corporation also participated in DTI missions to MENOPE 2008 in Dubai and RISE 2019 in Hong Kong. He coordinated with the company's IP agent for the local and international registration of Arnichem's trademark and patents. Everyone, let's all welcome Assistant Professor Ari Luis Halos.
So, good afternoon po. So, curveball kasi most of the previous those who shared about intellectual property mostly tackled patents and utility models. I'll go through the other side, which is yung trademarks, which I think is the parang low hanging fruit in terms of intellectual property. Why? Kasi you can anyone, basically sinabi kanina ni assistant director na pwede kayong mag-file ng trademark ninyo online anytime. And that's true, I did it during the pandemic. Nag-file ako dun, kaya lang hindi siya nag-grant, sorry. Pero meron ako na-file na copyright, na trademark during the pandemic. So hindi makagalaw mga tao, ganun. I shared with Doc Leo that I had to struggle with going through Dragon Pay. So sorry po. Baka pwede pong mag-Gcash, ganun. Pero no, that being said, so natuto ako dun sa na yon, sa experience na yun na mahirap palang mag-self-filing ng trademark. So lately, what I've done siguro share ko lang, na ginagamit ko na ngayon yung mga IP agents like ni Attorney Hechanova. So bakit mas maganda yon na gumamit kayo ng IP agent kaysa sa mag-DIY? Kasi what we're doing here in intellectual properties, we're staking our claim. So parang sa lupa ba? Diba? Sa lupa, madaling makita kasi meron kang mga landmarks, meron kang puyon, yung meron kang mga nomon. Pero sa intellectual property, paano mo i-stake ang claim mo? Kasi di ba, you're staking your claim to ideas. So how in the world do you do that? So di ba, pagka first time mo gawin, kaya nga hindi nag-grant yung right ko, kasi nga, yun, hindi ko alam kung paano ko i-stake yung claim ko. That's why lately, what I've been doing is that, I've been using an IP agent. So, bakit importante yung sa brands? So, ito malaking issue. Siguro meron ditong, baka may online person from Dubai, baka masabi niya sa atin kung totoo nga yung kwento, yung chismis na ang Angel's Burger nasa Dubai. Pero yung nagpatakbo ng Angel's Burger sa Dubai, hindi siya yung Angel's Burger dito. Na pareho ng pangalan, pareho ng signage, pero hindi magkaparehong company. Diba? So parang ang laki-laki ng Angel's Burger. Kumbaga, pupunta ka ron, makakabili ka ng buy one, take one. Ginagawa rin sa Dubai. Pero iba yung may-ari nung Angel's Burger daw sa Dubai. So paki-confirm na lang yung chismis kung totoo. Diba? Or parang so parang importante na you stake your claim to your trademark kasi you don't know kung biglang naging home run siya. Case ni Angel's Burger. Okay, but first coffee, di ba? Parang, ano mo ba yun? Ma-imagine mo nyo ba in your wildest dreams na you just started a burger joint or you started a coffee shop and then biglang pwede ka na maging millionaire or billionaire, di ba? So that's why lately I've been using an IP agent for my my IP needs. Ganun. So, bakit importante nga para sa maliliit na negosyante, like yung MSMEs, para to stake our claim on our trademarks. Kasi nga, you never know. For all you know, yung itatayo nyo na online business, maging malaki. In that case, pwede kayong gayahin. Like, yun nga, yung nangyari nga kay Angel's Burger, di ba? Sino pa makakala? Ang Angel's Burger, laki-laki niya sa Pilipinas, pero nag-aya siya sa Dubai daw. Okay, apparently. Ano pa ba ngayon ako? So, why is it also important at this point in time? Kasi I'm not sure if you're familiar with yung Liberation Day ni Trump. So ano ba ginawa ni Trump? He imposed large tariffs on various countries like yung Mexico and Canada na meron silang NAFTA, biglang nagkaroon ng malaking tariff. Ganon din ang ginawa niya sa EU. Ang pinakamalaki, yung sa China, 125% tariff. So ano ibig sabihin nun? Bibili ka ng upuan, sabihin na natin dati na bibili mo ng $10, ngayon magiging $25 na siya. So ano bang implication nun sa Pilipinas? Kasi sa China, 125% ang tariff. Pero sa Pinas, 10% lang. So how do we take advantage of that? I suggest that we use intellectual property kasi para makapasok ka sa China at magamit mo yung sa US at magamit mo yung 10%, pwede mong i-remanufacture yung mga products dito sa Pilipinas na galing sa China, galing sa Vietnam, galing sa Cambodia, of all places, or Laos. Laos and Cambodia, they got 48 and 49% tariff as compared to the Philippines na 10% lang. So ano bang pwede natin gawin? Or sa Vietnam na parang ano ba yung sa Vietnam? 46%. So pwede nyo gawin, bumili kayo ng North Face sa Vietnam, sabihin nyo, huwag nyo ilagay yung face, North lang. Pagdating sa Pilipinas, lagay nyo yung face. So North Face na siya, di ba? So pasok na yun sa remanufacturing. Simple as that. Actually, dati nga, ginagawa Gucci and yung mga ibang handbags, pinapagawa sa China, ang Italians, ginagawa lang is kinakabit yung zipper. And then they already qualify for yung EU tariff na 0. O, diba? So pwede rin natin gawin dito sa Pilipinas. So how do we do that? We use intellectual property. It's either through trademarks or, sorry sa pero pwedeng industrial design lang diba? As low as that. Pero if we are able to demonstrate to the US officials that it was substantially manufactured here in the Philippines, as evidenced by our intellectual property, makakalusot siya ng 10%. So, ayun, yun ang sigurong sharing ko on the other side of the coin, which is yung trademarks. So, thank you very much.
So thank you, Sir Ari, for your insightful discussion. So allow me to introduce to you our next discussant. He is the University Legal Counsel and Director of the De La Salle University Intellectual Property Office and Thank you so much, Attorney Cruz. I hope everyone is still with us as we are now down to our last discussion for the afternoon. He was a former IPO officer of De La Salle University, Dasmariñas. He received his PhD in political science from the University of Santo Tomas in 2013. Currently, he serves as the director of the University Research Office of the DLSU Dasmariñas. Let's all welcome We are now opening the floor to your questions and thoughts. Kindly raise your hand and we will acknowledge you, but please don't forget to state your name and your institution. You may also post your question in the comment or chat box of the preferred streaming platform, and we'll make sure to read them for our speaker to address. Unfortunately, Attorney Medrano and Attorney Badiola is no longer available for the open forum due to an equally important engagement. May I request our speakers here on site to come here in the front and our speakers online to open their cameras for this part of the program and discussants.
Pass the mic.
So, from Q&A from an anonymous participant, their question is, intellectual property rights are considered as intangible assets of research and I, uh, it's not addressed to anyone, but can we get insights from
Okay,
Attorney
so
Hedchat?
it's not reflected. Well, it could be reflected if it is purchased or sold. Kasi right now, hindi tayo pareho ng United Kingdom na nagre-reflect ng ano, no? Ng mga intangible assets sa kanilang balance sheet. So to be able to reflect that, kasi we follow certain accounting standards. So right now, when you sell something, when you sell an intangible asset, and then doon sa bumibili, it will be reflected as an asset. No? So ganun yun. There's got to be a transaction.
Thank you, Attorney Hechanova. Okay, so let's proceed to the next question. So this is for Mr. Joel Duque. So it's not
Set the limit for let's say for technology transfer. But what we have is the whole budget for grants in aid after deducting the cost of operations. Now, I am in favor of not setting a certain limit for technology transfer and commercialization initiatives, because when we started in 2017, we were only at 5% of total GIA. Now we are at 25%. What the DOST management want before is 10% or above. We chose going above. So setting a cap would be maybe not very helpful if you really want to be aggressive on technology transfer. Thank you.
Thank you, Director Katibog. So the next question is also addressed for the OSTP card. So the R&D budgets of Department of Agriculture and its attached agencies are very large compared to the R&D budget of the OSTP card. What interagency initiatives or whole of government approaches does the OSTP card implement with the agencies under the DA?
It's true. The whole budget of the DOST that's DOST, is about 28, 29 billion. That's much less than one big program in DA. Now, the S&T budget of DOST also, especially at Picard, we also support R&D initiatives of DA agencies. So, okay lang yun kasi ano na tayo S&T ang ano natin, ang gusto natin at saka R&D. And we are also in active collaboration with the Department of Agriculture, Bureau of Agricultural Research on how to harmonize and make our programs complementary, especially in minimizing or eliminating duplication in R&D projects being supported. So we always talk, the two agencies always talk, and we have signed a memorandum I think 2 years ago, so that we have regular meetings and updating on our programs.
So the other So the question is directed to Attorney Edith Hechanova. So it's a two-part question. So the first question is, under what IP form do you classify original and novel standardized employment? Novel standardized employment. The student admission assessment tools very much similar but different to the widely used industry tools like Binet Simon IQ test, Mayor Salovi Caruso Emotional Intelligence EQ test, and the Myers and Briggs Personality Type Indicator test. She added, I do not see such work included in the examples given in the table titled Summary of Intellectual Property Forms.
Well, most likely it would be under copyright, but it's got to be original. No? So kung hindi original, hindi siya copyrightable. So it can be maybe it can be an intellect, well, yeah, hindi siya copyrightable kung hindi siya original, ano. So yun na requirement. Kasi yung nature niya, it's something in writing, di ba?
Okay, thank you, Attorney. So the next question is there an age
But I know like the OST, they fund certain activities, no? So whether that is something within their program, maybe Director Noel can answer that.
For patents, utility models, and industrial designs, TAPI DOST has IPRAP, IP Application Assistance Program. For those IPRs I mentioned. For Picard, we do not provide direct support to agencies or individuals on filing and commercialization. What we do is we provide support to agencies and capacitate them so that they can respond to the needs of their constituents. So in this case, UPLB TTBDO is the closest thing, or maybe UP Diliman TTBDO is the closest thing where UPOU can approach.
From my experience kasi dun sa patenting, nung kinailangan namin nung patenting sa Indonesia, what we did was we applied with our region, with our provincial DOST. So DOST Laguna, they endorsed it to DOST Manila, and they gave some funding for yung patent application namin sa Indonesia. So why is it kasi sa Indonesia, Bahasa Indonesia yung language. So we needed assistance to translate the claims from English into Bahasa. Tapos yun pa, yung fees kasi sa Indonesia, bariyang-bariya kasi tayo Pilipinas compared sa kanila eh. Ang laki ng mga, basta yung we tried to commercialize our product there. Sabi sa amin, oh sure, but you have to bet $1 billion. O, di ba? Parang, saan ko kukunin yung $1 million? Di dito ko na gastusin, di ba? Pero anyway, ganun yung mga, parang, that's my experience. Naka-apply kami sa DOST Laguna. So, baka pwedeng ganun din yung gawin ni ma'am.
So is there any additional comments or you would like to add? So the next question is addressed to all presenters and discussants. This is from Mr. Arnel de la Cruz, a Zoom participant. This question of mine is addressed to all panel. How will artificial intelligence or AI will affect intellectual property? Don't you think the policy will be revised or amended?
I think most, if I may answer, I think most IP offices are studying it. But there have been, for example, some cases decided, for example, on copyright. Let's say a particular writing. It's got to be created or done by a human person, by a human being. Okay. So, kung siya ay may portion na AI generated, it should be disclosed and how substantial it is. It's got to be, hindi naman siya hindi pwedeng i-copyright, but kailangan yung human portion is substantial. So, disclosure ang kailangan.
Sige. Note ko lang yung kanina pinisent naman ni ma'am from IPO Phil. Kasi yung copyrights before, fina-file sa National Library. But kanina, pinakita na yung application for copyright can be coursed through IPO Philippines, and their form specifically states, meron talagang declaration doon what part of the work was done by AI. Ang medyo related dyan, pampagulo, sorry, pero yung Facebook, in training their model, they used copyrighted works without acknowledging the authors. So, paano yun? Ginamit mo yung Facebook, which used copyrighted works. So ngayon, kasi basically all AI, yung mga ano natin ngayon, yung mga large language models are essentially just, ano to, ang tawag nito? Sa matrix algebra lang yun eh. So it really just optimizes yung kung ano yung best word na susunod. Or best phrase na susunod. And those phrases can come from copyrighted works. So kunwaring nangyari, you applied for a novel, you applied for your copyright with IPO Philippines. You used yun nga, yung Llama 1 or Llama 2, which is Facebook's large language model. May habol sa iyo yung mga original copyright holders kasi yun, ginamit mo yung AI model ni Llama, ni Facebook, ni Meta, na ginamit nila yung without permission ng mga copyright owners. So, yan. Medyo, ewan ko, mas ano ni Ma'am Attorney Chanova yun. Pero that's something that you should bear in mind before you file for a copyright using AI works.
So thank you, sir. Ma'am Rosa has an additional insight. Yes po, ma'am. So thank you, ma'am. So this is also on AI. This is from a Zoom participant, Mr. Mark Mosuela Aquino. What is your assessment of the application of IPR in facilitating technology commercialization in AI intelligence, cryptocurrency, and social media application in the government sector? So anyone can answer. It's not
Kumbaga, ang sagot ko lang doon ay wala pa po kaming ganong experience or wala pa kaming technologies na hinahandle na dealing with those subjects, especially on the agri-aqua sector.
Thank you, Director Katibog. So, this is from Mr. Richard Almoela. And does the government want something in return for the grants and assistance they give to private investors?
Anyone, anything in return? Sige pa.
Okay, so the question is, does the government want something in return for the grants and assistance they give to the private investors?
If private investors mean those that establish startups and support spin-offs, then what we are only looking for when we provide grants under the Startup Grant Fund of the OSTP card is for the money to be used wisely and effectively in improving said startup or spin-off. We are looking forward always that the money that the government invested in those private companies will generate employment and revenues that would eventually be helpful to the economy. But as to money or royalties that DOST or DOSTP card expects from them, we don't have that provision, or we'll just return them to the National Treasury. So, no, it's not part of what we want from them.
So thank you, sir. So this is more on the practical aspect of IP. Since IP agents have a certain area of expertise, the question is how can inventors find the best IP agents to draft their patents? You have a practical tip.
Well, that's hard to answer, I think. Well, it would depend on the technology, but maybe what we can suggest is they ask around, or maybe look at patent filings and who are the agents who are filing and in what field of technology.
I'll contribute na rin kasi so all lawyers, yun, may law degree, but in the Philippines we all have undergraduate degrees leading law. So as a practical you ask the IP agent, do you have a lawyer who specializes in materials engineering, or at the very least engineering, or kumbaga in our case kasi it was biofertilizer, so ang hinahanap namin is a microbiologist. So swinerte kami nung time na yun, nandun pa si Attorney EJ. So grabe, ang galing niya mag-draft. Napalusot namin ng international. So yun, you can ask about, from your IP agent kung meron silang lawyer na ganun na background. Kasi it's kind of hard for an engineer to draft something in biology, di ba? Kahit pareho silang technologist. So I go that kasi yung magre-review kasi ng patent is an examiner who has a background in the field. Baga, yun yung yun yung parang kasi it must be obvious to the practicer of the art, yung patentability. So the examiner who is assigned to your patent has some background. So it also helps that yung magda-draft for you is also has a background. So yun lang ang ko. Ask for the CV.
If I may add, there are two basic categories for a patent agent. One is on chemical patenting, and that covers the chemical, chemistry, biological, microbiological inventions, and mechanical patenting or mechanical patent agents that covers machineries, equipments, etc. So, doon pa lang, alam mo na kagad kung kanino ka lalapit. And even if you ask me, you have a mechanical invention, I will not accept that being a chemical patent agent. But I can refer you to another one who specializes in those aspects. Even the chemical and mechanical, meron ding differentiation. Ngayon, yung mga apps, merong mga patent agents na nag-specialize sa apps. So, you just have to discuss this openly with whoever you will be approaching. But it does not mean that yung IP lawyer would know how to patent something that is far from his original expertise. Pero hindi din lahat ng patent agent ay lawyers. Marami ang hindi.
Yes, like for example, we have this association of patent agents, no? So our members have passed the patent agent qualifying exam. The IPOFIL will soon be conducting another set of examination. So a lot more patent agents would probably be qualified.
So for the Zoom,
I may add.
so from do you have any additional information? So this is a question from a Zoom participant, Dr. Max Makito. Would you say that R&D in the universities are significantly geared towards commercialization? My impression is that it's very low given the journal impact factor based incentive system in the academe. Yes, Dr. Jane.
May I respond to my colleague, Dr. Max Makito? He's my colleague in College of Public Affairs. Actually, the university has this culture, publish or perish, wherein faculty researchers would prefer publication because it's quick. In terms of points for promotion or points for your faculty service record, intellectual property, like utility model, has more points, but it will take quite a time before an engineer or an inventor from the university would get that. So still, TTBDOs in different campuses of UP would really strengthen its incentivization of filing for intellectual property. There was a time under another set of administration that we have financial grant for non-disclosure of your researches. And even non-disclosure, you are not yet filing for any intellectual property, but the system would help you, no, at that time. But I think the program has stopped. So I think it's 60K, 60,000 for patentable or commerciable researchers from different UP units, no. But still, publish sa academe, publish or perish. However, if they wanted to file a patent or any intellectual property, uh, attending conferences and presenting paper are more enjoyable because they have to travel. They can travel. So this is really a challenge and an exciting on how to shift, no, the focus of our faculty researchers into patent. Anyway, in UPLB, more of the patents are of this undisclosed information, more of the trade secret, because UPLB has been promoting, no, the technologies, particularly in biofertilizers and so forth. So undisclosed information na lang yung mga patent, and it's quite increasing in trend in terms of application, and we got, no, UP had got awarded by IPOPHIL, ano na nga ba yung diamond, platinum, oo, may palladium, lahat na ng metals, precious metals nandun na. So we try, but it's not really a perfect world. How we can shift, paradigm shift, publish or perish culture in the university.
If I may add also to what Ma'am Jean said, it's difficult to translate the technologies from universities because they also run out of funds. No? So usually the funding, mostly from the OST and Commission on Higher Education, it's just good for matagal na yung 3 years. But if you really develop a new technology or emerging technology, it takes time. So most of our technologies like the charging in minutes, Clean Gem, if you look at their timeline, it's a decade or more. Our mentor, Dr. Henry Ramos, it took him 8-9 years just to get the first license. No? So it really takes time. So most of our researchers, after getting the grant, it's either they do a follow-up research or choose another topic. And as what is mentioned also, that either you publish or you perish. No? So instead of filing for IP protection, most of the researchers, especially faculty, will either publish their work because in UP you also get incentivized when you publish. No? So the UP system is trying to implement new programs to incentivize also filing of intellectual property, but it takes time. That's why most of the faculty choose publication. In UP Diliman, we're also trying to come up with our own programs to incentivize our researchers when they file their disclosures.
Thank you, sir. So, Sir Attorney Cruz, do you have any additional insight? add something?
Yeah, just want to add, based on our data of
Hindi maganda
assisted
talaga yung kanyang ano.
So thank you very much for sending in your Zoom question. Unfortunately, due to time constraints, we are closing the open forum. So we've had an amazing time with all of your questions and of course your enthusiasm. Now it's time to show our appreciation to our wonderful speakers and allow me to read the citation. The University of the Philippines Open University Faculty of Management and Development Studies present the Certificate of Appreciation to Attorney Lolibet R. Medrano, Attorney Editha R. Hechanova, Director Noel A. Katibog, Attorney Karel G. Pabelinya. Sir, can you all stand? Thank you. Dr. Jane Kadok discussants during the Let's Talk It Over on focus on intellectual property rights and management, facilitating technology commercialization, and global competitiveness held on 29 May 2025 at the Audiovisual Room, UP Open University, Los Baños, Laguna. Given this 29th day of May 2025 at UPOU Open University, Los Baños, Laguna. Signed, Finaflor F. Thailand, Dean of FMDS, UPOU. So thank you very much to our resource speakers. Let's give ourselves a round of applause for making it through today's program. So to formally close our program, it is my pleasure to invite Assistant Professor Leo Mendel Rosario, Program Chair of the Diploma in and Master of Research and Development Management Program.
Over or LTIO webinar entitled Focus on Intellectual Property, Rights and Management, Facilitating Technology Commercialization and Global Competitiveness. Let me offer our most sincere gratitude to all of you. From the importance of IP in worldwide competitiveness, its function in public and private sectors, to the problems and solutions in technology commercialization. Today, we listen to a fantastic panel of resource speakers who walk us through the several aspects of intellectual property. We also had the chance to get insight into the IP registration procedure and how IP management is being implemented in the Philippines. To our esteemed speakers, Attorney Lolibet Medrano, Attorney Editha Nova, Director Noel Katibog, Attorney Ginalyn Sacmar Bajola, Dr. Karel Pabilinya, and Professor Jane Reyes, my mentor. We appreciate the time and expertise you have given us today. Your ideas are priceless. We would also like to express our sincere gratitude to our discussants, Associate Professor Magdaleno Vasquez Jr., Assistant Professor Ari Luis Halos, Attorney Christopher Cruz, Dr. Jose Ames Rosina, for their insightful answers and deepening the dialogue on IP management. I would also like to thank the organizing team at the back. No? Let's give them a round of applause for their dedication and service in implementing this hybrid webinar. Let's give them a round of applause again. Thank you. They worked hard for many weeks already. Special thanks to our MC, Miss Maria Dominique Velasco, and to our public service support staff, Miss Vanessa Autor. I would also like to thank our partner for this event, the Philippine Association of Research Managers Incorporated, or PhilArm, with its president, Dr. Diosdado P. Sulueta. And naturally, we owe all of our participants a great gratitude for your involvement throughout the session, from carefully listening into energetic open forum participation. Your presence today stresses the need of developing a greater knowledge for IP as we strive for innovation and sustainable development. I also proudly invite you to apply and enroll with the Diploma in Research and Development Management and Master of Research and Development Management here at UP Open University. If you want to apply, you would be considered for academic years of 2026 to 2027. Okay. We wish this discussion that this discussion simulated ongoing cooperation, education, and advocacy for ethical and purposeful intellectual property management across industries and fields. Stay connected with us with the forthcoming LTIO webinars, and remember to complete the feedback forum that would be flashed later. Once again, thank you very much and have a wonderful rest of the day. Thank you.
The Faculty of Management and Development Studies, or FMDS, is one of the 3 faculties of studies of the University of the Philippines Open University. It was established in 2004 when the then Faculty of Health Sciences and of Management Sciences were merged. At UPOU, courses are delivered online. Students study using specially designed learning materials and interact with each other in virtual classrooms. FMDS has 3 major functions: instruction, research, and public service. FMDS offers the following programs: Associate of Arts in Digital Entrepreneurship, Graduate Certificate in and Master of Asian Studies, Diploma in and Master of Environment and Natural Resources Management, Diploma in and Master of International Health, Diploma in and Master of Land Valuation and Management, Diploma in Land Use Planning, Diploma in and Master of Research and Development Management, Diploma in and Master of Social Work, Diploma in Women in Development, Master of Arts in Nursing, Master of Public Management, Doctor in Sustainability. FMDS conducts research both in our program disciplines and open and distance e-learning. We tap on our expertise in open learning and network technologies to address institutional, health, environmental, and social issues and problems affecting the country. To help disseminate research results, FMDS publishes the Journal of Management and Development Studies. FMDS offers micro-credentials and continuing education courses to cater to the wider public. These short-term courses focus on topics in the fields of health, environment, and entrepreneurship. We conduct capacity-building programs to help upgrade the competencies of institutions and professionals, as well as community-based programs targeting specific sectors. FMDS holds webstream seminars and symposia that feature vital issues relevant to the programs of the faculty. To further expand their reach, we have offered massive open online courses or MOOCs. Over the past year, FMDS has made significant strides in advancing its instruction, research, and community engagement both locally and internationally. At the heart of FMDS's mission is the CIDAS program where sustainability meets community. This initiative embodies the intersection of the faculty's three core functions: instruction, research, and public service. CIDAS, which stands for Community Inclusivity, Digital Transformation, and Acceleration towards Sustainability, unites the university's efforts in these areas to create tangible benefits for society. It also emphasizes the importance of university social responsibility, or USR, drawing the university out of its academic bubble and into greater service to the community. By employing SDG-focused, people-centered, and knowledge-driven assessments and interventions, CIDAS and USR work together to catalyze collaborative action among students, alumni, faculty partners, and stakeholders. This combined approach aims to build resilient and thriving communities that not only benefit from academic insights, but also contribute to the ongoing pursuit of sustainability. In 2023, FMDS initiated the launch of SILK, or the Sustainability in Action, a living laboratory campus. This groundbreaking initiative represents a significant advancement in our mission to transform the UPOU into a leading sustainability campus. The SILK functions as a transformative learning environment where sustainable practices, research, and public service are seamlessly integrated. This living laboratory design is in line with the vision to position UPOU as a center for sustainability studies. FMDS has also strengthened its partnerships with various local and international organizations. These collaborations have enabled FMDS to contribute to local development initiatives, particularly in the areas of health, sustainability, and community resilience, and its network through collaborations with esteemed institutions which have opened doors for academic exchanges, joint research projects, and the sharing of best practices in sustainability and development management. In this rapidly changing world, FMDS holds fast to its commitment to serve the global community of learners, scholars, and workforce. By providing responsive, interactive, technology-maximizing, and interdisciplinary and transdisciplinary programs. FMDS hopes to develop change agents who can make a difference in the lives of the communities they lead and serve.
So with that, we've reached the end of our program. Thank you very much, everyone. But before we wrap up, may we ask you to take a moment to complete our short event evaluation survey. Our heartfelt thanks to everyone who joined us today. We truly appreciate your participation. Once again, I am Maria Dominic C. Velasco, and has been the FMDS UPOU. Let's Talk It Over. Focus on intellectual property rights and management, facilitating technology commercialization and global competitiveness. Please stay tuned to our social media pages for the next session of Let's Talk It Over. Maraming salamat po, and thank you once again for being with us today. Thank you.